All right, good afternoon, evening, everyone, and welcome to the IU Robert H. McKinney School of Law. I am Karen Bravo, Dean of the Law School, and I'm really excited to welcome you to today's Bayh Lecture. Let us begin by acknowledging that we gather today on the traditional and ancestral territory of the Miami, Potawatomi, and Shawnee people, who were removed unjustly. We honor the heritage of Native peoples, what they teach us about the stewardship of the earth and their continuing efforts today to protect the planet. In addition, our campus and schools stand on the lands of a vibrant Black community, which was also displaced. As the present stewards of the land, we honor them all as we live, work, and study on this campus. Now, the Bayh Lecture was established here at IU McKinney in honor of the late U.S. Senator Birch Bayh and in recognition of his long and distinguished career in government. This year, our event takes place on a particularly appropriate date, September 17, which is Constitution Day and National Voter Registration Day. Thank you to all of those who made this lecture possible. The Simon Property Group, where Senator Bayh served on the board for 17 years, and to the Friends of Birch Bayh. We're very grateful for the support over the years of Senator Bayh's widow, Kitty Bayh, and their son, Chris, who's here tonight. Hi, Chris. Unfortunately, Kitty Bayh was not able to join us in person tonight, but she has been a great friend of this event and of our school. Senator Bayh's accomplishments in the Senate were numerous. Amazing, really. He's the only person since James Madison to draft multiple amendments to the U.S. Constitution. He created the framework for the presidential transition through the 25th Amendment on presidential and vice presidential disability and succession, and the 26th Amendment lowering the voting age from 21 to 18, and the Equal Rights Amendment, which could yet become law. He's also responsible for landmark legislation such as the Privacy Protection Act, the Juvenile Justice and Delinquency Prevention Act, the Bayh-Dole Act, Title IX of the Higher Education Act, and the Disaster Relief Act, which was the basis for the creation of FEMA. Our topic tonight is the 26th Amendment to the U.S. Constitution. In the shadow of the Vietnam War, Senator Bayh's 26th Amendment lowered the voting age from 21 to 18, enfranchising Americans previously called upon to serve their country, but not old enough to vote. As usual, Senator Bayh was humble in discussing this achievement. He said, "I had the good fortune to be able to right an injustice that I thought was being heaped on young people, where they were old enough to die in Vietnam, but not old enough to vote for their elected officials who sent them there." Now, you'll be interested to know that Constitution Day is a national day, and that Purdue Political Science Department also celebrated Constitution Day today by recognizing the legacy of Birch Bayh. We're very pleased that a number of participants in that program have joined us here this evening. First, the principal speaker at Purdue earlier today, Jay Berman, who was Senator Bayh's chief of staff and who spoke about the senator's efforts to amend the Constitution to provide for the direct popular election of the president. Mr. Berman. Hey. We're also pleased to have join us Purdue political science professors Logan Strother and Jesse Croson, over there in the back. Just as we are very pleased to have so many Purdue political science graduates among our students and alumni here at IU McKinney. Tonight, our speaker is a leading scholar of the 26th Amendment, Yael Bromberg. Yael Bromberg is a constitutional rights attorney with more than 20 years of experience in community organizing, legal advocacy, and campaigns. She counsels and represents individuals, organizations, and unions in state and federal courts across the country. Her docket includes election law, voting rights, free speech, ethics, civil rights, and labor cases and projects. She developed her scholarship while teaching and supervising litigation in the Georgetown University Law Center Civil Rights Clinic and Voting Rights Institute. She also received her LLM in Advocacy with distinction at Georgetown. Her article, Youth Voting Rights and the Unfulfilled Promise of the 26th Amendment, is widely cited and has been dubbed a groundbreaking study. She's a leading legal scholar of the 26th Amendment and is an architect of the Youth Voting Rights Act, a comprehensive federal legislation to enforce the 26th Amendment. At Rutgers Law, she teaches election law and the political process and served as faculty advisor for the first legal volume dedicated to the 26th Amendment. She is a visiting associate with the Eagleton Institute of Politics and is a principal of Bromberg Law, LLC, where she practices democracy law. Before gaining this illustrious career, she graduated from Rutgers, both undergrad and law school, and then clerked for 3 years with the Honorable Dickinson R. Debevoise in the United States District Court for the District of New Jersey. So please welcome me in joining Professor Bromberg, and we will reserve time for Q&A after her remarks. Thank you.
You're invited to do a presentation for somebody who actually worked to ratify the amendment, which is a fun project. Jay, it's an honor to have you with us today, and thank you for all your work. Very nice to meet you, and it's truly an honor to be here to celebrate in honor of Birch Bayh, such an enormous architect of constitutional precepts and major congressional statutes, many of which we continue to benefit from today. Dean Bravo really charted us through some of the main provisions that he helped to advance. The 25th Amendment, which I believe probably informed some of his acumen around ratifying, pushing through the 26th Amendment, as well as then being pushed through his efforts on the 26th Amendment to be made aware of for the advancement of the Equal Rights Amendment. And of course, abolition of the Electoral College, which continues to be relevant today. Some of the lessons that I've learned from looking at Senator Bayh's offerings is that the Constitution is not fixed, right? We can continue to engage in the act of constitutionalization, and that's both on the federal level and on the state level, and that massive institutional reforms can be accomplished. I think that sometimes we become a bit disengaged and apathetic, but the legacy that Senator Bayh has left us is an opportunity to lean in and not to opt out. And that there's another value here in terms of appreciating what the process of constitutionalism looks like. Sometimes it's holding public hearings, even when an amendment may not ultimately be ratified, but for the benefit of fleshing it out and having scholars come and participate in that process. And sometimes it's even to inform yourself in changing your mind on an issue, such as Senator Bayh, where he adjusted his perspective on the Electoral College as well. I think there's a value in approaching this work with a sense of humility, that we can all change our minds and we can all engage in the process progressively. The senator was a part of the Kennedy generation, and what I've learned by looking at his history, which is still living history, is that he worked closely with many of the folks that we know from history, right? He worked with Ted Kennedy, Senator Majority Leader Mike Mansfield, Presidents Kennedy and Johnson. And the acts that led to ultimate ratification of the 26th Amendment were these actors engaging in a process together. And what I've learned by looking at this work is that this is not so far away. This was only 50 years ago, and we continue to learn the lessons of that today. And interestingly enough, once he was elected in November 1962, he convinced Senator Eastland of Mississippi to not dissolve the subcommittee on constitutional amendments and to establish him as chair of that subcommittee, which allowed for this flourishment of a second Reconstruction in our Constitution. I will not ask you to raise your hand to see if you know or knew what the 26th Amendment was before coming here today. I've learned my lesson. Thank you for your honesty. But what I've learned through this process of discovering this amendment is that there are promises that it offers that are as yet unfulfilled. And in many ways, this is a forgotten amendment, although it's the most recent voting rights amendment to be ratified in the US Constitution. This is just a bit about myself. I'm currently working on a project across 4 states and colleges on a new course called Student Voting Rights, Politics, Power, and Race in the Fight for American Democracy, which brings together HBCUs and private institutions as well in the discussion. I've written 2 articles, Youth Voting Rights and the Unfulfilled Promise of the 26th Amendment, and The Future is Unwritten, Reclaiming the 26th Amendment, which was the intro for the first legal volume ever to be published to celebrate this amendment. 50 years later, the first symposium was just held to reflect on what this amendment can offer us. I've learned giving these lectures that I have to tell you what it is before launching into the history. So the rights of citizens of the United States who are 18 of age and older to vote shall not be denied or abridged by the United States or by any state on account of age. And Clause 2 allows Congress to have the power to enforce this article by appropriate legislation. This language might look familiar. It looks a lot like the 19th Amendment on account of sex, and it looks a lot like the 14th Amendment on account of race, national origin discrimination. And it is a part of the evolution of the right to vote doctrine. So we have the first Reconstruction, which allowed for the 13th, 14th, and 15th Amendments, and then the 19th Amendment, right to vote free of sex discrimination. And then this bourgeoising process of the second Reconstruction, which is generally considered between 1954 with the Brown v. Board of Ed decision requiring desegregation of our school systems to 1967. And during this process, we had the inclusion of new amendments like the 24th, the 25th, oh, I need to put the 25th on here now, and the 26th, and new congressional statutes that were passed to enforce amendments previously ratified during the first Reconstruction. And so oftentimes when you hear about the 26th Amendment, it is for good reason put into the context of what was happening with the Vietnam War. But when we place it within the second Reconstruction, you can understand how architecture was essentially established during the second Reconstruction to allow for the 26th Amendment to finally reach a tipping point in 1971. And from that perspective, I consider the 26th Amendment as being an integral part and expansion of the second Reconstruction, not simply a footnote or an add-on later. And how did this come to be? In 1960, February of 1960, we had the Woolworth sit-in in Greensboro, North Carolina, which launched desegregation sit-ins across the nation, led by HBCU students, which informed the Freedom Rides and then Freedom Summer. And at all of these movements, including the women's rights movement, it was young people who helped to lead the way with multi-generational support. And by the time that the anti-war movement came about, the ratification of the 26th Amendment was, I don't want to say a certainty, but these young people that worked at the front lines finally turned to themselves and said, we need to enfranchise ourselves as well. Here's some images of young people working together, Fannie Lou Haber in the center with Heather Booth, who's a seminal organizer and continues to do good work. Here you have John Lewis, then chairman of SNCC, and then beloved congressional leader. What I find very interesting in this process is how this is all connected, right? Because when we look at history, sometimes it's in black and white images, and we think of events as being completely disparate from each other. and looking at the perspective of the 26th Amendment, specifically from Senator Bayh's perspective at the time. On Friday, June 19th, the Civil Rights Act finally passed the Senate after a 72-hour filibuster. And that evening, Ted Kennedy was rushing to get to a campaign event with Birch. That evening, there was a terrible plane crash, which was tragic, which had loss of life. The Sunday following, 2 days later, 3 civil rights workers disappeared. And on Monday, their mothers were called to say, we don't know where they are. Bob Kennedy, while his brother was recovering, in fact, Senator Bayh had pulled Ted Kennedy out of the plane and was himself suffering from physical injury along with his wife. Bob Kennedy immediately led the charge for federal investigation into what happened in Mississippi. And go back, who allowed for the new creation of the subcommittee on constitutional amendments? It was Senator Eastland from Mississippi. Okay? All of these things are all connected and happening at the same time, which is why it's so easy to compress them when we look at them in retrospect, unless you lived through them, and then you have a different perspective, perhaps. A week later, President Johnson signed the Civil Rights Act into law. And the following March, Bloody Sunday, March 1965, when then chairman of SNCC, John Lewis, was beaten on the Edmund Pettus Bridge. And the Voting Rights Act finally introduced 3 weeks later and signed into law that August. So going back, right? Young people were leading and involved in the Second Reconstruction. And finally, towards the end of that period, they turned to their own enfranchisement. And this enfranchisement and the way in which they organized was through the Youth Franchise Coalition, which brought together this amazing coalition of organizations which had already been in touch during the process. This included the Let Us Vote organization, which had previously been established, the NAACP, the National Education Association, which was integral to the process, the YMCA, the Christian Leadership Conference, and a range of folks from Union, there's the American Jewish Committee, the National Students organizations, and even the Young Republicans debated joining, and their chairman had endorsed this initiative. And ultimately, the ratification effort, as it went to the states, the 38 requisite states to ratify the amendment into the United States Constitution, was led by Common Cause, then a new national organization, which I'm proud to have worked for Common Cause for several years. The Youth Franchise Coalition first endeavored to ratify, lower the voting age to 18 and outlaw age discrimination through amendment of the Voting Rights Act in 1970, Title III. I don't want to go too far into the weeds, but this ended up going up to the United States Supreme Court in Oregon v. Mitchell in 1970, where the Supreme Court said, Congress can pass a law to lower the voting age to 18, but only with respect to federal races and not state or local races. And so then a tension occurred because the 1972 presidential election was coming up. I think it's interesting to take a look at the language of what Title III offers. It's still a good law, actually, at least with respect to the federal races, which I think a lot of folks don't fully appreciate. It prevents the denial or abridgment of the inherent constitutional rights of young people to vote, which have the effect of denying the due process and equal protection of the laws that are guaranteed to them under the 14th Amendment. See, here you still continue to see this informing by equal protection principles that do not bear a reasonable relationship to a compelling state interest. This is strict scrutiny, right? So the constitutional lawyers in the room, they know that when strict scrutiny is applied to analyze a law, this is the hardest way to allow voter suppression to continue. And eventually, because of the reality of what was going to happen with a dual system of voting, 18 for federal races, 21 for state, created this push for the ratification of the 26th Amendment. So what's interesting here, it passed the Senate 94-0, the House nearly unanimously, and it did it in less than 100 days. This is the quickest amendment to be ratified in United States history. What motivated its passage was a recognition of the value of moral purpose that young people offer in re-energizing the practice of democracy, their increased competence due to the standardization of public education at the time, which had not been available previously, and the availability of technology, including the television, which could broadcast news. Margaret Mead actually testified in favor of it as well. The increased adult responsibilities of the group to go to war, to assume debt, to live independently, and a general recognition of the expansion toward a more inclusive suffrage. And finally, stemming unrest, which was popular in time, recognizing that there needs to be a form of institutionalization to engage in social change that did not involve protest and being in the streets. The Senate report that referred the amendment to the states provides, and I think that this is really key for interpreting what potential violations exist to the 26th Amendment today, that forcing young voters to undertake special burdens, such as obtaining absentee ballots or traveling to one centralized location in each city. What is that? That's an off-campus polling location, right? Or elections being held when the students are not in session. That's when the primaries are. For example, in order to exercise their right to vote might well serve to dissuade them from participating in the election. This is not necessarily talking about voter suppression from an anti-discrimination perspective. This is about political engagement. This result and the election procedures that create it are at least inconsistent with the purpose of the Voting Rights Act, which we just previously looked at, which sought to encourage greater political participation on the part of youth, and such segregation might even amount to a denial of their 14th Amendment rights. This language looks a lot like Title III of the Voting Rights Act that we just looked at, which might inform that such violations should be subject to strict scrutiny. And so from this perspective, we have to remember that the 26th Amendment is a part of the evolution of the right to vote. And it did not simply lower the voting age to 18. What it did was prevent the denial or abridgment of the right to vote on account of age. Just like the 19th Amendment provides from denial of the right to vote on account of sex, on account of age can be much larger than simply talking about the promise of the 26th Amendment with respect to youth voters, right? Ruth Bader Ginsburg provided for the protections afforded not only through the 19th Amendment, but the 14th Amendment by conceptualizing on account of age by looking at discrimination of men, right? And therefore expanding the right to vote. When we talk about on account of age, it may well be that in 50 years, the 26th Amendment can also be interpreted to prevent age-based discrimination for seniors or for other age cohorts. And the future of the amendment is largely unwritten, which makes it really fun to explore and think about today. When I look at, and I work with young people across the country in various states, and the types of special burdens that appear are very interesting because it means that when a young person's voter registration form is rejected, and when they appear to vote at disproportional rates and are given a provisional ballot, or their vote by mail ballots are rejected at disproportional rates, we're talking about a systemic violation of the right to vote and not a one-off because, discounting the ability of a young person to navigate the election bureaucracy. These are systemic issues that require systemic solutions. So I'll just give you a few examples without getting too lost in the weeds here. Strict voter identification laws. In states like Texas and Tennessee, you can vote with a handgun license and not your student identification card. And in Tennessee, there was actually a decision that identification issued by the university for faculty members was appropriate for using for voter identification, but not identification issued by the same institution for students. Thank you. Thank you for who's listening. And in Wisconsin, I would not say that it's the strictest voter identification law in the country, but it is interesting to take a look at what the impact of it was. So in Wisconsin, the voter identification, the student ID permissible for voter identification can only have been issued within a 2-year period. So how long do you go to college for? 4, 5, 6 years maybe, if you're a graduate student too? The students have to know that their student ID has to be taken back in and reissued in a 2-year period in order for it to count as valid voter identification. And the first year of this Wisconsin law's implementation was the 2016 presidential race. And Wisconsin saw the second largest decline nationally in youth turnout. There are 300,000 students enrolled in Wisconsin colleges and universities, and the state's voter margin that election, you'll recall, was only 23,000 votes. These are systemic impacts caused by violations of the suspect protected class. And there are provisions that can prevent this, such as election day registration and voter portability. We have the mechanisms to make sure that these votes can be protected. Our election administration process is actually very solid from that perspective, and because we have a federalist system, we can look at other states that do this very well and see how it results in voter turnout, including by youth voters. I'll spend a moment talking about vote by mail law because this is actually of importance to Indiana specifically. And before doing so, I'll remind you that in the 2020 election, when COVID required election modernization across the country, 70% of youth voted earlier by mail. Usually when you vote early, it's considered by mail too. It's classified that way in the system, in large part due to the election modernization. And we saw unprecedented voter turnout overall, the highest turnout in the 21st century, which courts have upheld the results of. With 67% of all citizens over 18 years old voting, that's 17 million more voters that participated in 2020 compared to the prior presidential cycle. And yet, in 7 states in the nation, vote by mail is restricted on account of age, including in Indiana. 7 states discriminate on the basis of age in their vote-at-home systems. They are Texas, South Carolina, Indiana, Tennessee, Mississippi, Louisiana, and Kentucky. And I co-authored a report to look at the results of what that discrimination looks like in terms of the data. We found that the data shows that age discriminatory laws, no surprise, affect voter behavior. People under 65 made up a substantially larger portion of those voters in states that do not discriminate on account of age, 61%, than those that do, where 35% voted by mail. And these discriminatory policies deny younger voters access to at-home ballots that they would otherwise use. Nationally, 22.5% of voters 18 to 24 used vote at home, or vote, aka vote by mail. 22% nationally, but in age discriminatory states, of which Indiana is one of them, only 6.6% of voters ages 18 to 24 voted by mail. These are just a few of the other special burdens, such as campus gerrymanders. In North Carolina A&T University, which was home to the Greensboro 4 sit-in that we looked at earlier from February 1960, there is a campus gerrymander that cuts a congressional district right through the middle of campus. And if you look at the lines over the campuses across the country, you'll see curious patterns that occur. And because the 26th Amendment is so forgotten, there's no analysis that even really looks into this. We just don't even analyze it or try to extract data of it. And therefore, we can't appreciate the impact of it. And the availability of on-campus polling places, which is a particular passion of mine. In Florida, the Secretary of State issued a ban of the availability of on-campus polling locations during the early voting period. And we sued, I worked with the League of Women Voters and the Andrew Goodman Foundation to sue and overturn that ban based on the 26th Amendment. This contributed to a statewide change in law. And in New York State, only 35 minutes north of New York City, on Bard College, which is a very bucolic campus, they refused to allow, the Board of Elections refused to allow for an on-campus polling site on campus. And we sued repeatedly and won repeatedly. And it eventually mobilized and encouraged a change in state law to mandate on-campus polling locations across the state of New York. So we can look at these examples of where states allow for election day registration to make sure that students that move, young people that move so often, can update their voter registration on election day and cast a successful ballot. We can look at other laws expanding the access to vote by mail, et cetera, in other states to modernize and have huge impact on electoral margins. And I don't say this from a partisan perspective. I say this based on there are voter suppression laws, purposeful or otherwise, seen or unseen, that prevent a protected class of voters from engaging in the franchise. And if this occurred for any other class on account of race, on account of sex, we would say blatantly that it's unconstitutional. But because the 26th Amendment is so kind of forgotten within the relics of history, we need to engage in more public education, analysis, discussion, advocacy, and litigation, and of course organizing, to popularize the amendment to fulfill its full promise. One of my efforts to do so, not that I have any hope in it passing anytime soon, but at least to create a template of what this might look like, is the Youth Voting Rights Act, which was introduced by Congresswoman Nikema Williams, who holds the current seat previously held by the late, great John Lewis, and Senator Warren. And this, I'm not going to go through this list, but it essentially tries to cure many of those special burdens that I outlined previously. And all of this really, what I want to impress on you is that these little individual experiences that young people might experience, that they might have to overcome in terms of engaging with the electoral system, have massive impact. And youth voting also is on the rise, and it's emerging. Youth voters are emerging as a crucial block. In 2014, in 2020, overall 50% of young voters voted, compared to 39% in the 2016 election. In 2022, they particularly voted in battleground states and states where key referenda was on the ballot, such as access to women's bodily autonomy. And the population is shifting to boot. So the youth population, particularly in these states that you'll see on the bottom, are becoming increasingly racial minorities over time. And so what may be obvious age-based discrimination will start to more and more appear as age plus race mixed discrimination. 2024, this election, millennials and Gen Z plus will outnumber the number of boomers among voters. In 2028, they'll make up 49% of the eligible electorate. In 2036, they'll constitute 60% of the electorate. How are we engaging them? We've learned that voting is habit forming. And so by teaching them how to vote and vote successfully earlier, we help to build a more sophisticated and engaged citizenry in a lifelong manner. These are some of the pictures of young people that I've worked with, protecting, this is the young woman on the upper right. She was protecting the availability of on-campus voting in Fulton County, Georgia. On the bottom right, this is Bard College president who engaged in the litigation as a lead plaintiff with Bard senior student Sadia Saba, who's also a plaintiff in the case, where we litigated to establish the on-campus polling site. This is them walking to it early on election day. The other piece that I like to remember in this is that young people have always been leaders in writing the story of America. So Alexander Hamilton, he was in his early 20s, one of the nation's founding fathers, and Frederick Douglass, he was 23 when he took the stage at the Massachusetts Anti-Slavery Society meeting. Alice Paul, she was in her early 20s when she began to lead the suffragist movement in this country. And so while it might be easy to write off young people as apathetic, tuned out, wrong, disengaged, etc. I see this as an invitation to lean in and to work with them. I think that our nation's history bears that out, and this will only protect our future if we do so. So I'll pause there and take some questions. There's so much more. I can literally talk about this for days, but I tried to keep this abbreviated for tonight's purposes. Yes. I think that that's absolutely right, and that's the offering. I mean, when we see such low, I've done a lot of work on primary ballot reforms, independent of the 26th Amendment, but we see such little engagement in the primary elections, then you have to wonder who is being elected to represent your interests during the general. And let's just take it back to the youth voters. When they move, like during the summer period, for example, when they're in between residences, how can they vote at their on-campus location, right? The 26th Amendment protects their rights to vote. So this is also incumbent on all of us to find creative solutions. And in some college institutions, they've actually offered residences, addresses for those students in the interim period and engaged with them to make sure that they vote during the primary. Of course, it's their choice. If they want where, they can vote wherever they determine to be their home and their permanent residence. But particularly when we see such low number and engagement in the primaries, this is an invitation, we're required to lean in and find institutional systemic solutions.
Tremendously educational, and it got me wondering to what extent you think that the protections that are provided through the 26th Amendment, do they all apply in your mind to primary elections, or because the primary elections are wrapped up in party politics, does that create a trickier opportunity for violent suit and so on and so forth across the state?
The case law is a bit conflicted on this because you would think that you might interpret the amendment to say, for example, if you're going to be 18 by the general election, then you should have the right to vote during the primary. The case law does not bear that out. But there are still opportunities. For example, in certain states, we have pre-registration of 16 and 17-year-olds so that they can vote, and they can be registered to vote, and they have somebody to instruct them during a civics course or otherwise on what that process looks like. So it's not the first time that they have to navigate it when they move or go to college, for example. But in other states, those laws are very confusing. Like in Texas, the pre-registration law, you have to be 17 years old and 10 months in order to register to vote, right? Can you imagine being a high school teacher for seniors and trying to distribute and engage? I mean, that is just so confusing. And so there's a range of opportunities for a lack of clarity. And pre-registration laws are wonderful, but we also need to accompany them with civics education and portability and election day registration, because those voter registrations are not going to transfer if that person moves, for example, if the young person moves to attend college or to move on outside of their parents' home.
Professor Bromberg, I assume you're aware that there was a challenge to the Indiana scheme that discriminates against voters less than 65 years of age who wish to cast a ballot by mail. And I assume you're aware of what the outcome of that decision was, as well as the fact that the Supreme Court denied cert where do we go from there? I mean, it seems to me that litigation options have really been narrow in terms of challenging, at least to vote by mail inheritance discrimination.
Yes, thank you for your question. I did not go so far into it because there's so much to discuss in this area, but you're absolutely right. The Seventh Circuit, so this age discriminatory vote by mail law that I discussed, that's available in place in 7 states, including Indiana and Texas, was challenged before the Fifth Circuit and the Seventh Circuit. I believe that the Fifth Circuit case is still in litigation, that the Supreme Court, Justice Sotomayor wrote a dissent when it was up on appeal to the Supreme Court and said, we still have to explore what the rights are afforded essentially by the 26th Amendment, almost an invitation to do further education. But the jurisprudence that was created by those decisions, and they cross-reference each other. So you have one decision issued and then the second one piles on and cross-references are extremely troubling. And they rely on a Supreme Court decision, McDonald, in which, in McDonald, the Supreme Court upheld a restriction on the availability of vote by mail for eligible voters who are serving time and are incarcerated. And the way that the McDonald decision was reached, I believe it was in 1975, or maybe it was 1970, 74, thank you. The way that that decision, we'll have to talk later. The way that that decision was reached was by saying that vote by mail, which was then a bit antiquated, it was not as prolific as it is today, is not protected by the right to vote. Vote by mail is not protected by the right to vote. Tell that to the 70% of young people who voted by mail or early using vote by mail ballots in the 2020 election. Tell it to the people who are in their 50s who want to vote by mail free of an excuse, but you have to be 65 plus in order to do so. So this is extremely troubling, and I also think that we can look at some of the lessons that Senator Bayh offers here, that the process of constitutionalism is not always quick, that sometimes it's long, and that we need to engage in more public education and discourse and analysis around what these rights offer. And because of the politicization of the federal bench, we also, in certain areas, we also have to look for creative solutions elsewhere, like state constitutionalism, like in Montana, for example. They have a very robust state constitution, which was informed by ratification of the 26th Amendment, actually, when they came together in 1970, and they embedded those rights within the state constitution. And so you're absolutely right to be concerned around the jurisprudence of the 26th Amendment, but I still have hope. And some of that is looking at other litigators that have come before us, such as Ruth Bader Ginsburg, when she transformed our understanding of violations of the right to vote on account of, or just violations on account of sex. And, you know, these young people are being restricted. They're not just Democrats, they're also Republicans. Right? And so the lessons that are learned from the 26th Amendment, which is the quickest amendment to be ratified in US history, which passed the Senate unanimously, is that this is a nonpartisan amendment. This is about the future and not about political division. And so I hope, because when we talk about age-based, the protections of age are a bit different than the other forms of constitutional classes, like sex or race or national origin, because age is fixed, it's immutable, it does not change, and yet it does. And so from that perspective, age as a protected classification is something that we all experience, God willing, and it unifies us. And so, you know, maybe it's a bit too optimistic and too hopeful, but I do think that there's some value to that. Right? Maybe we need to bring a 26th Amendment on behalf of Republican youth who are being disenfranchised, for example. Maybe that will open up and remove the partisan tint of, you know, basic voting rights and political reform today.
State constitutions say anything about age discrimination in voting?
So the state constitution, thank you for your question. So the federal constitution does not have an express right to vote within the federal constitution, but the state constitutions actually provide the right to vote for 18 years plus. and specifically the right to vote. And so there's an interesting area of law that folks are now starting to reinvigorate, which is state constitutionalism. Look at, and oftentimes the states, they want, because of just the dynamics of federalism, they want to be able to interpret their state constitutions, perhaps informed by federal constitutional interpretation, but also independent of it. And in many states, they do so in a more robust manner. It's a bit of like a home rule feeling, right? And so, yes, I think it's 49 states in the nation expressly provide for a right to vote for 18 years old plus. And the other one does it by implication.
There seems to be, well, it's just precedent. There's a concerted effort to reduce the number of voters. Those of us who've had children know that within a week we got a social security number for our child, which follows our child from state to state, address to address. So if we wanted to make it easy to vote, it wouldn't be a problem. But the movements to repress voting are just become shockingly novel. Ken Paxton, our beloved Texas AG, has now sued counties that are sending applications, not ballots, but sending applications out. I can't even imagine what offense that presents, but he's threatened them. So what can we do? I mean, the national trend is fewer, and we have youth who, you're absolutely right, have always been at the forefront of every social movement. How could that change direction other than in the ballot?
I think we have to lean in. I think that when people see that somebody wants to monkey around with your ballot, you inform them, and it makes them make sure. Yes, I registered to vote. By the way, today's National Voter Registration Day, purposely set ahead of voter registration cutoffs across the country. So make sure the people in your orbit are registered to vote, in addition to Constitution Day.
Yes, that's right.
How many people have you registered to vote today, right? This is such a question, right? There are things that each of us can do to increase the number of registered voters. They're all around us.
Absolutely, thank you. We should be all engaged in this practice of democracy, and it looks different for different people based on who you are and how you interact in the world, but we can all engage. One of the things is to make sure that you fill out a form, or a young person in your life fills out a form. Make sure that form is actually in the system. Call the Board of Election. Don't assume. Please do not assume. That's how we get the provisional ballot rejection rates that's outsized for this class. You have to track, right? You requested a vote by mail ballot, put it in the calendar. When do you expect it to return? When is its due date? For young people in particular, and this also applies to out-of-state students, this is very complicated because they also have on-campus on-campus mailing systems that may not prioritize election material, right? And so we all have to engage. Our colleges and institutions have to act as civic actors. We have to engage the folks around us. Track your ballots, track your voter registration. When you look at these narrow rates, or just the primary as you raised earlier, you can actually have a tangible impact on the results. And so this is an invitation, right? You tell a young person somebody's trying to take something away from you, right? Yeah, as they should be.
So as an incoming law student, I mean, my question is, how do my peers not help contribute to the vote against systematic discrimination? What do I tell my friends? What do I do for myself?
Well, you have a state law here that discriminates on account of age for vote by mail ballots. That law can be changed in the state legislature. That's not a federal law, that's a state law. And I bet you that they're not even aware of it. I bet you that they're not aware of how unique their circumstances compared to the others in the nation, or the bedfellows that they share in similar laws. And there's other great pro-voter tools like election day registration, availability of online voter registration. I mean, we have the ability, you call your doctor's office, you call your insurance company, They'll tell you every single thing about everything that you've ever done, right? We need to modernize our election systems. But in the meantime, we can work by looking at the methods available in other states to ensure best practices here. Also, do you have an on-campus polling location? That's something you can achieve by going to the Board of Elections, right? You can just put together a presentation. I work with young people. There's a toolkit that's online at the Andrew Goodman Foundation's website based on best practices of students advocating for on-campus polling locations. Secure one on campus, right? And then make sure people use it. And then the next step, like one of my young colleagues in Fulton County, Georgia, he made sure that it was the first polling location in the country that was fully equipped by students. They were protecting their own, they were the poll workers, they were the greeters, right? They worked together to help each other. So there's a million things that, there really is truly, I mean, this is an embarrassment of riches of what we can do. We just need to kind of organize, and we need to lean in.
The premise of my question is sort of the philosophy that in order to participate in the decision, you ought to have a stake in the outcome. And I remember when the amendment came into effect, I was a student at IU Bloomington, and actually I was born and raised there, so I had family there that kind of different things. So I just wondered what the law is now with respect to having a stake. There's a lot of reaction to quote unquote, why should we let the students, vote for our county council, vote for the mayor? Obviously, they have a stake in the presidency of the United States, but if their home of record is another country, another state, what kind of restrictions, or what's the law about that?
Yeah, thank you for your good question. So this is a state-by-state law, but it comes from English common law, so there's some generality to it in the US, which is what, generally speaking, what is the place that you consider your home? Easier said than understood, right? If you are an adult and you have multiple homes in different states or part of the state, which do you consider to be your home, right? That's a very subjective question. For young people, they have the ability to, make that decision for themselves. We should not apply the magnifying glass to young people in the same way that, in a different way than we would apply to other age cohorts, such as vacation homes or, high mobility kind of situations. But what I would say is that for young people, they do have a stake locally, right? They have a stake in making sure, for example, that there are rent control laws available to them, which is a local decision. They have a stake in making sure that there are local resources available to them that their local politicians would have to pass, and on the statewide level as well. Interestingly enough, when the census is conducted, they count the students on campus, right? Exactly, and then their appropriations go out, and so that is all based on student availability and representation. And the other piece that I'll say on this is, I do think that it's very easy to discount intentional or unintentional voter suppression when you're looking at young people, because they're learning and they're, it's easy to kind of discount them. But in places like college towns, that young person may or may not stay, but that group, the student population, is fixed, right? There will always be that number of student population. And so there might be a bit of transience there, but there's also a bit of permanence there. So I think that, again, it's an invitation to engage and to not look at the young people as carpetbaggers. You wouldn't say that to an older person that moves into town. Should you really be voting here, right? We have very high mobility rates across age cohorts. So the rules that we apply to young people should be the same rules that we apply to other groups. And I have some interesting anecdotes of that just from the courtrooms, like, somebody wants to discount the voter rolls that came in. Actually, I experienced this in a county in New Jersey, in a town in New Jersey. They tried to discount the voters that came in, and they looked through the lists, and because the voter registration lists are available, including the column for date of birth. And they basically, what I realized by kind of reverse engineering what they did, was they selected the voters that fell within an age cohort, and then they searched for them online to see where their other touch points might be. And we said to the court successfully, we said, would you allow for this type of approach if it was any other classification other than age? If we did this to women voters or white voters or any other type of group, would you allow for that? No. And so we should properly discount that here.
Just a quick question. You talked about specifically Indiana's changing the legislature on the age for mail-in ballot. Has anybody in any state did just a cost analysis of the difference between people who vote at polling place compared to what it takes to maybe count mail-in ballots or something like that? Has there ever been a situation that you talk to state legislatures, you want to talk about money, what's it going to cost? So is there a study someplace around that kind of says, okay, per voter, this is what it costs, full per voter on a mail-in vote, this is what it costs? Ready?
Frankly, I'm not aware of that. There's other studies I've seen around like access to, postage required free election materials, but I have not seen that specifically. The difference between the cost for in-person voting versus vote by mail.
Because of the handling, whatever else,
Yeah.
But now obviously computers and things, it's kind of rev that up a little even more efficiently than it used to be back.
Absolutely.
When I first started voting, but I just don't wonder if anybody ever did a cost analysis.
I think that would be interesting, and also how do you determine what cost counts, right? The voting machine technology that's available in Washington State and in Oregon State, where they have universal vote by mail, you don't have to request it. They send it to you. They have the highest voter engagement rates in the country. That technology, the machines are quite large, and they just collate them. You just put it in. So you're not paying for human labor in the same way, but you're paying for the machine, which may last. So I think it's this, economic analyses are always interesting, but it's also a question of what else are we factoring into this? What I think I'll leave you with, unless there's any other questions, is that when we're talking about voting, we're talking about a fundamental right, which the entire constitutional system is premised on. So I don't think that there can be kind of a question here about expanding the availability of that fundamental right, making it work securely and safely and easily, making it accessible. And that should apply to all voters, but I find it very interesting to look at the way in which it appears for young voters, because generally speaking, when we expand access to the ballot for young voters, that affects everyone in a positive way. We overcome obstacles that we think are solved and have yet to be fully fulfilled. And we should really be working towards, there's some very interesting and creative solutions around election modernization, including looking at comparative law that we can take a look at, like in Australia, where you have mandatory voting. And what does that mean? It's just kind of a tax incentive to vote. And voting can actually be very psychological. Are you opting into a system or are you opting out of a system? When you go to the DMV, are they proactively asking you, are you not interested in registering to vote versus are you interested in registering to vote? So we have a far way to go in terms of election modernization, but just bringing it back to the senator, this is all possible. It's possible to do this. And amazing things can happen if we work together. It has huge impacts on the margins, and it just allows for a much more robust democracy. And again, I say that free of partisanship. This is a nonpartisan issue. And the young people now are going to be the future. We should prepare them well to do it because of how broken everything is right now. Thank you.